Good afternoon and welcome to our July Residential Property Forum, joined once again by Ian Quayle. Good afternoon, Ian.
Hi, Robert. How are we?
I'm very well, thank you. I was just telling Ian that being an excellent ex-conveyancer, I didn't realise when I bought my house that the front wall was falling away. So I'm at home today as they try and repair that and make it look as attractive as possible. So there is a warning to us all to actually be careful when we're buying properties ourselves. Lots of topics to talk about today. Also got a guest joining us to talk about some of the other useful services we can give. Ian, if you could move my slides on. So yes, as always, just to remind you, Stewart Solution is an online ordering platform for title insurance. You can get cover up to £20 million on the most popular policies, and there are over 150 different types of policies on there. We're working hard all the time to update and improve the system. We will be having some changes coming out in the next few months, which will make it easier for you to combine policies and to effectively bespoke the policy to your client. In the meantime, they are on there if you'd like to have a look at Stewart Solution. We'll show you some details in a moment how you can do that. Where any problem becomes too complicated to be done online, and obviously in development situations or in more complicated matters, that's the case, there's an immediate referral through to our highly experienced underwriting team. And we have, in the course of this year, added 8 new underwriters to our team. The reason behind that is, as well as wanting safe and secure policies, you do want them speedily. You want them to be in a way that you can use them and trust them and not interrupt the transaction. So we've added to our team there to hopefully do that. As well as these sessions, which we do with Ian, residential and commercial property forums, we do hold regular in-house webinars on legal topics. I've just been arranging one today for a firm where I'm going to do some training on the regulations regarding title insurance and what you need to tell your clients and what you need to know yourselves. We can organise those as teams or in-person events, and we're very pleased to talk to you about those. And if you could move the next slide. And these are the details if you're interested in any of those things. If you want to sign up for Stewart Solution or have an inquiry, there's the address there. If you've got any other business development issues regarding perhaps commercial policies or bespoke policies, use our BD underwriting team address there. If you or any of your colleagues are dealing in Scotland or Northern Ireland, my colleague Liz will deal with those, her details there. And if you are interested in any webinar or training, there's my details to get in touch. And otherwise, Ian, I think we've got a full programme, so I'll hand over to you.
Yes. Before we do that, Rob, just one or two things. First of all, massive thank you to Stewart Title for sponsoring these events. And also, Stewart Title sponsor Property Law UK, our monthly electronic publication. The latest edition comes out tomorrow and is a bumper edition. I was just talking to our editor. Got over 120 pages of articles and case law reports, including a case I'm going to be sharing with you this afternoon. And the other thing, as far as Stewart Title is concerned, that I wanted to mention was the fact that, in addition to providing product, title indemnity insurance, Robert and his team have a vast amount of experience with regard to issues, title problems, etc. So Robert was saying about underwriters, there's a resource there for you. Whilst you might be encountering something that's unique and you've never seen before, my guess is Robert and his team will have encountered or may well have encountered that issue before and may well have advice and guidance that they can give you, as well as a product. And the other thing Robert mentioned was speaking at a conference just recently, and someone was asking about seller identity insurance, and someone had said that they'd checked and Stewart Title were the only insurers that were providing that, which is interesting. So if anyone is acting for a buyer who's worried about seller identity fraud, speak to Robert. He has a product that can protect not only the client, but also your firm in the event of a wipeout due to seller identity fraud. But on that note, Robert, thank you for introducing us today. Thank you for sharing the slides. And what I'd like to do now is to refer you to and introduce you to my dear friend, Mr. Mr. Richard Pickles from InTouch Case Management. I've known InTouch Case Management for a while now, Richard. I met Dale, I think it was a law society, and it was Nottingham Law Society many years ago.
That makes sense.
Really, really interested in what Dale had to say and their story with regard to product. The fact that her and her husband were unhappy with the conveyancing process, and I think he's the IT genius.
He's
And Dale is,
yep,
yeah.
He's the guy that built the system for sure.
Yeah. So I'm delighted to welcome you along again, Richard, to explain to people attending today about your work at InTouch. Again, if you don't mind, I'm happy to attempt to move the slides as efficiently as possible. So over to you, Richard, and thank you for joining us today.
I'll let you know when they need to move on, Ian. Don't worry at all. Hi, this is me, Sales Director of InTouch. There's my contact details as well, just below that. Next slide, please, Ian. Won't take up much of your time, everybody. What I'll try and do is I'll talk in general about case management systems and what you should be looking for. Obviously, I will refer to InTouch, but we're not about heavy sales pressure or anything like that. So I'm generally just talking about what you should be looking for in a case management system. We are a very, very flexible system. So it works across the law. It was initially built for conveyancing, and due to, as Ian mentioned, a real amount of frustration that the two founders, Dale and Marvin, found with regards to losing two properties through fall throughs when they were buying their own house. And Marv, being an IT engineer, he decided to do something about it. So here we are today, but the system that we've built is flexible, so it's not limited by jurisdiction, it's not limited by the type of legal matter that you're interested in. We have over 600 different legal workflows on the system, so it can do anything for you. And you should be looking for that. You should be looking for a case management or a practice management system that covers all aspects of law, and that works for you and is flexible enough to flex for you and become your system, and it follows your practices as well. Although there are some key elements of a lot of practices that need to be borne in mind and can help do things like ensure that you're compliant and so on and so forth. Anyway, so as we said about InTouch, not restricted by jurisdiction. We've got customers all across the UK and Northern Ireland. There are some of the logos of the firms. You may have come across some of them. Some of you may even be on this very webinar today. We have clients in Australia as well. And we've recently picked up some clients in Kenya and South Africa. So InTouch is not just growing within the UK, we're growing worldwide. First Class Legal are the Australian one. What I quite like here is that the marketing bods have put those dots in Australia right in the middle of the continent, which, as most of us know, nobody lives there. So and everyone lives around the coast in Australia. So please don't expect those to be accurate, but not limited by jurisdiction, not limited by legal practice either. So next slide, please, Ian. Your case management should also take the hassle out of everything that you do. We have asked for measurements, and we save on a conveyancing matter 45 minutes per case of phone hassle, actually towards the top end of that. So the saving of 2 to 3 hours is across all matters, 3 hours, because a conveyancing, especially a resi conveyancing matter, tends to be one of the more complex ones. It has more third-party involvements. It has things like client portals and so on and so forth. And so the effect is better. And the saving is about 3 hours per matter there, and huge reductions in call and email drops, nearly a third since people implement InTouch. And again, you should be looking at that. You should be looking at something that allows you to get on with doing your stuff rather than responding to calls, emails, and so on and so forth. Next one, please, Ian. What should you cover? Nowadays, you should be looking at a system that basically covers everything from the start of the matter, attracting people in to open up a case in the first place, getting the leads in there, getting a quote generated, that kind of stuff, right the way through to post-completion and invoicing and financial as well. So making sure that you've got a quote. We embed quotes on clients' websites. We embed a quote generation tool even on some of their introducers and their referrers' websites as well, which automatically create a lead within the case management system and allow you then to onboard compliantly using digital forms specifically made for the process and getting e-signatures as well. We have our own e-signature solution, which means that there's no limit to the amount of e-signatures that you can use. And we find with our clients that getting a signature early gives a sense of commitment. So you get less fall through in that case, or somebody going off to somebody else. Obviously, we have workflows. As I said, InTouch is extremely flexible. We can build workflows specifically for you. We do supply standard workflows, but very quickly we start moving them about to make sure that they work for you. It should be your workflow. We shouldn't be telling you what to do. Likewise, we can generate documents, emails, and we use AI specifically. And I think Ian's going on to talk about AI later on in the webinar. We use AI to take the boring and repetitive tasks out of what you're doing, again, to improve your life, to make sure you can concentrate on what you've been trained to do. Next slide, please, Ian. Automation is one of the key things as well. So you get tasks within your workflow to send out automated emails, secure messaging for your phones, and also using client portals for stakeholder management, but not just buyers and sellers. Drag in there your estate agents, drag in your mortgage brokers, drag in even giftors or someone like that, just so that they're kept in the process. Really makes a big difference in reducing the number of emails and phone calls over time. Initially, you might see a slight spike where people go, what's this, what's that? But then it soon calms down and you get much, much less calls from specifically your professional referrers who understand the process a little better. You would expect your case management to conduct the searches so that you got your due diligence sorted, and we integrate obviously with some of the key search providers, and also the risk management through anti-money laundering and know your client stuff as well. We've already jumped onto the portals already through the stakeholder management, but it really helps with regards to the sales progression and obviously the audit history as well, which just everything that has ever been done on a case or a matter is recorded and date stamped and time stamped as well as you go through. Next, please. Here. In other areas of law, obviously, accounting for work and time capturing is important, and obviously you would expect a case management system to do that. We're talking to a conveyancing audience, so obviously there's a lot more fixed fee work here, so that doesn't matter as much. And then following completion of the case, we've got full client accounting, we've got completion statements, and then real-time and really, really flexible reporting, which can look at performance, not just internally, but perhaps the performance of your referrers as well. So who's giving you good leads, who's giving you bad leads, and so on. Really, really key data. And obviously client feedback as well nowadays becoming more and more important as people actually want to see that on your site. What's your Trustpilot score and that kind of stuff. Next one, please. Here. So we do integrations, as I mentioned. Some key integrations there that we've got. We've got InfoTrack, we've got TM Group, and Third Fort are the ones that jump out there immediately to me. There's also Pally, PLS, there's others as well. The integrations are not the issue that they used to be 5-10 years ago. They're a lot easier now, and your case management system should have been built with open integrations in mind so that they're easy to do. So if you've got someone you want to connect into your case management, it shouldn't be a problem. Xero as well is there, which is an accounts-based one. Sorry, next one on. So why do people choose us? We're 100% cloud-based. That means that essentially, if you've got an internet connection, you can jump onto us. If you were by the sea and there was you were sunbathing on holiday and you just wanted to have a look and see if that case had got over the line, then you could actually have a look on your phone, basically. It means also that it's scalability as well. So if you're a growing business, or even if you're, you have people leave the business, just add a user, take a user off. It's massively flexible. Of course, for cost effectiveness as well, doesn't mean that you have to have a server and have a big stack in your office in a separate room that you have to maintain, and it means that you have to look after your own security. We're responsible for all of that. So cloud-based is good. I've mentioned complete practice. I've mentioned multi-jurisdiction. It's multi-platform friendly. So yes, laptop, desktops, tablets, telephones, apparently even works on Macs as well. And we've run through the integration. One of the other things about being cloud-based is that you've got continuous updates. Updates don't have to be installed on your servers. So whenever you log on, you can be absolutely confident that you're actually on the most recent and up-to-date version of your software. Transparent pricing is a must, and I think everybody deserves that now. And our pricing is on our website, which is intouch.cloud. And flexible contracts. So the days of tying you into long contracts for case management systems are over, and they should never return. So, we do monthly or annually pricing with a discount, obviously, for annually, and that's it. And you are basically tied to the system for your payment term. And the rest of it, we should be good enough to make you stay. And that is the way we run our business. And as a result of that, we conduct thorough onboarding, and we have actual human beings providing support. Our support's really important for us. We resolve, and we measure this on a weekly basis, over 90% of all queries from our users on first call. And we're very, very proud of that. Getting started, as I say, we map your processes. We make sure that it's easy to move over to InTouch, and moving case management shouldn't be a problem. We build your workflows for you and with you. A lot of our customers find our workflows very easy to build themselves. You don't need to be a coder or anything like that to build workflows. It's very pictorial how to build a workflow. Even I can do it, and I'm not any kind of IT tech expert as well. We also onboard your team, we train you, and then continuously support you with ongoing webinars. There's one going on right now on AI, actually, as we speak, and also training sessions and help tools as well. Thanks, Ian.
Thank you, Richard.
That's it. That's me, Richard, and it's Richard at intouch.cloud if you need to get in touch with me.
Thanks, Richard. It's always a delight to talk to you. I was smiling when you were talking about the outback in Australia. The first time I ever spoke to a client on a mobile telephone, he was driving a pickup truck somewhere in the outback of Australia. So I'm on a telephone call to him and I hear a bang, right? And this guy, there's sort of well, I think there's some very colourful language, to be honest with you. And the guy sort of got out of his pickup truck. He'd hit a kangaroo.
Wow.
The kangaroo was all right, okay, but there was about 2 or 3 minutes where I couldn't hear anything. I wondered what on earth had happened. But he came back to tell me that the kangaroo was fitting well. His pickup truck, the front of it wasn't so well, but it would live, and off he went into the sunset. So when I saw your picture of and I was trying to remember where he was based. It was somewhere ridiculous in the middle of the place. And you're right, it is a desert, and not many people about. Yeah,
absolutely nothing there. But clearly, the people who work in our marketing team aren't aware of that.
Absolutely, yeah. Never mind. Anyway, Richard, delight as ever. The beauty of In Touch, the beauty of Stewart Title. Richard, Robert, they're supportive of the profession. They're not pushy. They don't have to be. They've got products that sell themselves. But Richard, so kind of you just to share, the generalities that are useful for people to know and the specifics about your product and your company. So thank you so much. Now to the sort of the main theme of today, which is to look at topics, etc. Remember, chat facility, put any topics that you want to explore in there. As ever, I refer to useful websites. I just want to share some of them with you. I've just done a webinar this morning on adverse possession, and Property Protocols has a boundary dispute protocol which you can access. Really, really useful for dealing with boundary issues, boundary problems, and adverse possession. And I mentioned Property Law UK, the last website on site here. This is our monthly electronic publication sponsored by Stewart Title. 120 pages of text going out to practitioners tomorrow night. Subscription service, we'll show you on the last slide today about the costs relating to it. But important point, as Stewart Title sponsor Property Law UK, if you are a client of Stewart Title, and if you ask Mr. Robert Kelly very nicely, I think there may still be some free subscriptions available courtesy of their sponsorship. So talk to Robert. And as I say, if you are a client of Stewart Title or a potential client of Stewart Title, if you talk to Robert, I'm sure there's a facility there that means you can have a free subscription. If anyone's interested to know more about Property Law UK, send me a note and I can send you some details in any event. Anyway, topics. First of all, climate change and conveyancing. We're all aware of the Law Society guidance. Hopefully, we've all read the Law Society guidance. Question, Ruby, have you, Oliver, have you read the Law Society guidance on climate change? Robert's mentioned, by the way, there are some free subscriptions of Property Law UK, so do get in touch with Robert and he'll sort that out for you and we can sort it out for you. But on climate change, the latest Law Society guidance for conveyances is not that scary, to be honest with you. As long as you're doing what you were supposed to do in the original guidance, which I think it came out in June 2023, you're going to be all right. Always recommend climate change report, always highlight to client in very general terms the potential risk associated with climate change and property ownership. I don't think you have to do much more than that, to be honest with you. Again, we've done some webinars on climate change and climate change reports over the years. If anyone's interested, we can ensure that the links to the appropriate webinars are made available to you. Anyone encountered any problems with the latest Law Society guidance on climate change? To be honest, again, criticism of the Law Society, you know, we're transactional property lawyers, and I think the original 2023 guidance, which alluded to the fact you need specialist training and you should be explaining risk, etc. I think there was a mixed message there. You know, I think all you need to do is say to the client, I can get a climate change report for you. I'd recommend it, but I can't give you detailed advice concerning content, but the report provider can. I think that's put simply where we need to go. The next thing I wanted to talk about was the National Risk Assessment of Money Laundering and Terrorist Financing 2025 regulations issued last week. Has anyone read them? My thinking is no, we won't have read that because we're too busy. I have read it, and there is something in there that I want to share with you because I think it's important. First of all, general point, it is massive Zara, yeah. But the general point that I think we need to take from this, we need to be revising our policies with regard to money laundering and assessing risk. We've got to, at the very least, acknowledge this latest guidance. Do you agree, Zara? And the point that I took from the guidance was A, the fact that conveyancing remains a major issue with regard to money laundering. B, the guidance highlights conveyancers do deal with prime or super prime property purchasers, more likely to be exposed to higher risk persons. So I would say if your current CQS policies, money laundering policies, don't deal with a specific risk assessment for prime or super prime property purchasers, an allocation of different techniques, strategies, and policies relating to such transactions, I think we're missing a trick. The reason that the guidance highlights prime or super prime property purchases, so the first thing I would do is define what I mean by that. So insert a value, which would be, in your view, sort of extraordinary from a value perspective, and then ensure that you have a risk assessment that appreciates the likelihood that the person buying the property could be politically exposed or could be an overseas buyer, and therefore is going to be a higher risk client involved in a higher risk transaction requiring enhanced due diligence. And as far as that enhanced due diligence is concerned, it will require an assessment of sources of wealth. So what's everyone's views about that? If you were acting on a prime or super prime property and anyone thought or already deals with what is prime or super prime, again, what sort of source of wealth checks or assessments would we undertake? Can I just throw into the discussion today, prime or super prime property? Perhaps depending on our location, if we're out in the provinces, we might be saying a property whose value exceeds £1 million. If we're in sort of prime or super prime property areas, I'm thinking of places like Windsor or Guildford, etc., we might increase that value. So I think we've got to define prime or super prime properties for our risk assessment purposes. And then as far as sources of wealth, we've got to have a procedure for that. Zara was saying, and you're quite right, Zara, yes, Google the client, what do they do for a living? But I think it's more than that. I think we've got to identify what they do for their living, and we've got to look at their circumstances and background. So are they involved in a transaction which is consistent with their status? So that's going to be really interesting, isn't it? So I think, you can't just say, what do you do and where do you live? I think source of wealth involves more than that. So it involves sort of getting to know the client. And I'm thinking here, we're looking at, have you inherited wealth? Are you in business? Is that the sort of business that would generate wealth? What sort of wealth will it generate? Of course, where we're concerned about high cash intake, again, we're going to have issues. But we do need to revisit our policies and procedures. Yes, Zara, people do tend to have money from all over the place. Christopher, I'll come on to your question in a moment, but thanks for that. Just dealing with this sort of source of wealth point. I would have a series of sort of questions to ask the client. And the other thing here, of course, is we're being quite intrusive, aren't we? So I think when we're onboarding the client, we need to explain why this source of wealth research is necessary. So I think we'd have to disclose to the client, well, your transaction involves the purchase of a prime or super prime property, and therefore we've got to undertake additional risk assessments. And where someone as an individual is a higher risk person, again, we've got to say you also fall into that category, and therefore we are obliged to assess your circumstances and may ask fairly intrusive questions in order to get satisfactory responses. The important thing here, Zoe and Zara, is that we make sure that we are asking, if we're generating questions, that we're answering the questions and we've got a record of the answers to those questions and how we've arrived at the conclusion of our risk assessment. So, I'm happy to act for the MP or government minister who's buying an £11 million property in St George's Hill in Surrey. And this is why. One, this is a prime or super prime property. This client is a politically exposed person, and therefore the transaction is high risk. The client is high risk, and therefore, as a consequence of that, these are the measures that we've put in place. We're assessing sources of wealth. We've got our money laundering compliance officer or our head of department or a senior fee earner undertaking additional risk assessments as the transaction progresses. And I think the other thing is we don't just do this when we're onboarding the client, but we have to have, and I would advocate you have particular points in the transaction where you reassess risk and that everyone is aware that there are red flags or there are indicators as the transaction progresses that warrant a particular additional risk assessment at that point in time. So, okay, that was my point with regard to this new guidance with regard to money laundering, etc. I did recently, since the last time we were together, a webinar on cryptocurrency. And again, the reason I did that was, one, I'd been asked by one of the big law firm groups to do something for the group on cryptocurrency transactions because they were being asked about it. Secondly, don't know about you, but a lot of my pals, business acquaintances, etc., were telling me that they were investing in cryptocurrency and they were doing this and doing that and doing the other. So I thought, well, we've got evidently clients that are getting involved in cryptocurrency, but we've got firms of lawyers who have been told by professional bodies, etc., not to. And so we've got a bit of a mismatch here. So, what's the position? The interesting thing with regard to that webinar is that no one who attended was willing to conduct a conveyancing transaction where the buyer had any funds that were being used in the purchase that was cryptocurrency. And the point that I learned, having researched cryptocurrency, is that there are risks, not only with where the client gets the money from to invest in cryptocurrency in the first place, but there's risk with regard to the cryptocurrency platform. Where's it based? Are there jurisdictional issues? And some of them there are. But then the client's crypto wallet, where is the company that created that wallet based, and are there jurisdictional issues there? And again, my research revealed there were some crypto wallet facilities that were based in places like North Korea, Russia, and Venezuela. Well, immediately jurisdictional issues with regards to that. So again, I'm going to ask everyone, anyone here today undertaking work where you'd be willing to accept fees or monies from a client with regard to the provision of those monies via cryptocurrency? Just if you are, or you're thinking about it, there are companies now that will undertake due diligence with regard to how the cryptocurrency was purchased and what happened when it was purchased. Because there's another issue with regard to cryptocurrency that I hadn't thought about, and that's you can't invest 10 grand in cryptocurrency. That £10,000 is now worth £150,000, and the client is using that £150,000 to facilitate a purchase. Not only should be checking where the £10,000 came from, but how has that £10,000 now manifested itself into £150,000? And are there any issues relating to that source of increased wealth that would generate money laundering issues? Anyway, enough of that. Christopher, hi Christopher. Becoming positive, right, when acting for a seller when indemnity covenant is required, I insist on receiving the buyer's signed transfer counterpart. Happening every time, although it's never been given as a reason by a buyer's list. Something in my mind makes you think there might be a get out of jail for the seller in Emmet. The Leicester Land Registry once raised this in respect of registering a covenant, i.e. you can't take the benefit without the burden in a deed when registering a covenant, but I can't find it. The point I make for the seller is insisting that when the buyer sells, the buyer's solicitors may be asked to prove the buyer gave an indemnity. If it's not on the title, it will not be able to do so. Well, I get your point, and I have some sentiment with that view, Christopher. I'm going to open it to everyone else. What do we think about in Christopher's situation? Would you, as a buyer, want an indemnity covenant from the seller And do you think Christopher's right on receiving buyer's signed transfer or counterpart? I think you would do that. Meanwhile, while we're exploring that theme, Donna, yeah, it is high risk. And Donna, it's high risk because of A, where did the client get the money to invest? Why is he investing in cryptocurrency? What happens if it suddenly leaps in value? And where is the cryptocurrency based? And where is the crypto wallet based? So, yeah, I'm of the view, Donna, that I wouldn't be willing to act. But all I'm saying is I think that we're going to encounter more and more pressure to act. Okay. And as I say, there are companies now that will check and vet cryptocurrency. But even that, I would still say I'm going to follow National Crime Agency, SRA, and Law Society and other professional body stances not prepared to act. Yeah. So Sue, Christopher, you've got support for your covenant point, and I agree with both of you on that one. Christopher, Richmond puts money into gold and shows he could have thrown it. I can't see a difference with crypto. Well, the problem with crypto is Christopher, the point I alluded to, right? If that cryptocurrency is based in Russia, there's a jurisdictional issue with regard to that increasing in value, and the same with regard to the crypto wallet. So you've got to look at the legality of the increase in value as well as the original source of the deposit into cryptocurrency. And yeah, well, again, Zara, okay, the issue there is potentially problematical, but again, if it's converted into sterling or converted into currency that we're willing to accept, how far do we go? The interesting data, if going back to money laundering, that I saw was, let's just have a look at it. I've just highlighted it. With regard to money laundering issues, there were 240 fines issued in the 23-24 reporting period, only 33 fines in 2022-2023. So there's a few points there. On money laundering issues, firms are being clobbered with regard to fines, and it's not a question of the AML being breached and therefore you're being fined because there has been money laundering. It's non-compliance with the creation of policies. So if firms are non-compliant with money laundering regs, I think there's the Council of Licensed Conveyancers have produced some data. Just have a look at it for you. Firms found non-compliant by the Council of Licensed Conveyancers 2021-2022, 48% of firms were non-compliant. 2023-24, 66%. And there's no doubt in my mind, professional bodies are on the warpath about this. And the reason they're on the warpath from this is the National Crime Agency is saying conveyancing is the hole in the bucket with regard to money laundering. So all I'm saying is look at this new guidance, amend your guidance and policies as a consequence. Next thing I want to talk about is artificial intelligence. The reason I want to talk about artificial intelligence is I was talking to a dear friend of mine, barrister called Nigel Clayton from King's Chambers. I call him Mr. Boundaries because he deals with boundary disputes that appear before the courts in the Yorkshire area. He's the go-to judge for such disputes, and he's a really nice guy. Anyway, Nigel was telling me that his work as a judge has involved him recently being exposed to artificial intelligence. And a guy called Richard Susskind, who's a professor of, I think it's technology or something weird and wonderful at the University of Oxford. Richard is the guy to go to with regard to artificial intelligence in the legal context. And I've just reached out to him this morning, having purchased 2 of his books, to see if he'll do some work with me on training relating to artificial intelligence. So look out for that. That could well be coming shortly. But the point I want to make is both Nigel and I were of the view that AI was sort of slowly taking over some aspects of all legal work, including conveyancing. But to see AI sort of really taking over jobs and really potentially replacing the work that we do, we're probably 5 to 10 years away. Anyway, Nigel reckoned that having heard a presentation from Richard Susskind, that 5 to 10 year period is wrong, and we're probably talking about a 2-year period. And the reason for that is we've got artificial intelligence, which currently explores the library of the internet when asked a question, and scours the internet and finds what it thinks are answers to the questions that were posed. Sometimes it gets it right, sometimes it gets it wrong, sometimes it gets it hopelessly wrong. Okay? But currently, that's what artificial intelligence that we're using is doing. What there is out there is something called artificial general intelligence. And what this does is it doesn't think as a human, but it's as near as technology can to thinking. So the reason that the judiciary have been interested in artificial intelligence is it possible for artificial intelligence to take over the work of the judiciary? And the answer seems to be yes to that question. And Richard Susskind talks about having, the idea of going to court in an old building and spending 2 days paying for car parking, etc., is ludicrous. And the reason that litigation is so expensive because of the need to attend court and all that goes with it. So he's saying, or he foresees, that AI taking a lot of the sort of cost implications of litigation out of the equation, therefore making litigation more affordable. Really interesting stuff. But with regard to artificial general intelligence, the thinking there is that we go to the next level. So we're not asking a artificial intelligence to tell us everything it knows about restrictive covenants or prescriptive easements, but we're saying to artificial intelligence, here's a set of circumstances, here's a conveyancing file, and I've got a restrictive covenant that my client buyer is concerned about. Is it enforceable? And it seems to me that artificial general intelligence at some point in the near future is going to say, yes, it is, or no, it isn't. And that choice, that answer to the question, is going to be a better answer than any lawyer could provide. Because if government and the judiciary are saying, that artificial intelligence is going to be sufficiently sophisticated to be able to decide court cases, then it's not a million miles away from that to AI to decide the sorts of things we're talking about. Now, there's an interesting point here. Is Richard Susskind saying we're doomed? I don't think he is. And I think what he's saying is, as a lawyer or as a professional person, our life is going to change, but we're not doomed. And he thinks, and he looked at this in the sort of medical context, which was interesting, and saying that what artificial intelligence will do at the moment is, robotics for operations, assessments, diagnosis in connection with illness and disease. He's saying that what artificial general intelligence will do is be utilized to prevent and be preventative medicine rather than reactive medicine. And he also says that if you look at, say, music and what artificial intelligence can do, artificial intelligence as of today has created a band and has created music. But the whole purpose of going to watch a band or listen to music is in part to be amazed by the fact that a human being is capable of creating that song or that music and then being able to play the guitar or the saxophone or the drums, and that people will still want or prefer to see a human group or a human composer as opposed to AI. And he then translates that into the legal context and says, rather than a client going into a sort of a lawyer's office and sitting down with a computer and typing in the issue and uploading the documentation and the AI then generating an answer, Richard's view is, and I endorse this, why wouldn't I, is that the lawyer will still be required to say, look, This is useful, and I support it, or it seems to be right, and these are the implications. So I think it's the same thing. So Robert, hi Robert. Yeah, I agree with that. Yeah, I think the current AI is definitely that. But what I'm interested in is this artificial general intelligence, which is sort of next level, and that's great. But yeah, currently, I think it absolutely is to be treated as a precedent, to be treated cautiously and nervously. If you notice, a lot of the tools used for creating reports on title, etc., and I've been party to this, require the document which AI has used as a source document for the wording to go into the report. In most of the reports on title I now see sit alongside the actual report itself. So I've seen there's a product called Art, produced by Navro. There's a report on title produced by Express Legal Services. There's a report on title produced by Infotrack and Orbital Witness. All of these use the same thing. So you see AI producing your report on title, but alongside it, seeing the conveyance, the official copies of the register, whatever is the source document, so you can check it. So I think, Robert, that is a sort of manifestation of the point that you're making there. And I agree wholeheartedly with the point that you've made. But it's really interesting. The takeaway really today is be alive to it, and don't spend fortunes getting geared up to it. But I think it's going to be upon us far more swiftly than we thought. And this second generation, if it's a second generation, it may be more than that, is going to be really interesting. But ever the optimist, I think that the role of the lawyer, the role of the doctor, etc., still will exist, but in a slightly different form. I've covered reporting on title in doing that. Okay, and on reporting on title, Zara, yeah, lack of personalization, yeah. Most of the ones I've seen, Zara, so they have a standard library, but they allow you to personalize, and I think that's so important. And I think the other thing, Zara, is I like the idea of reports on title as a framework, basically going back to Robert's point, and I like the idea of interim reports on title too. Yeah, Robert. Well, I mean, there's barristers that are being criticised, haven't they, for skeleton arguments that refer to case law that doesn't exist. Yeah, because as I say, at the moment, it's a librarian that's extracting books and sections of books and cases, etc., that it thinks are relevant that may not be. So I think it is fundamentally flawed at the moment, but it will get better. And there's some AI that has been specifically created for law firms, isn't there? There's one of the Magic Circle firms has its sort of own AI product that's learnt via their systems and processes. So I think we're going to see that. But yeah, Robert, you're right, 100% on that one. Okay, so reporting on title, I like interim reports on title. I like an executive summary. I like a report on title that refers to client objective. Defective title insurance. Robert, I think you're still with us. Robert, I was noticing you were saying about your influx of new underwriters, which is good to hear. Robert, just a quick chat about my views with regard to defective title, and just to see that you agree with me. One, I think some firms are not saying to clients when they're closing their file, or reminding clients when they're closing the file, about the fact there's a defective title insurance policy being taken out, and about the client's duties and obligations. I don't think it's enough simply to highlight to the client what those duties and obligations are when the policy is taken out. I think it is useful and good practice to remind the client of that when we're closing our file. Do you agree?
Yes, I would, Ian. I think there used to be, back in the old days of the loose leaf, write your own ones, a sort of habit, which I think we all got into, of doing the policy and then just sticking on the file and forgetting. It is a live document. It will have use for your client in the future. So they need to be aware of where it is, or who the policy is with. And then, as you say, also be aware of the rules regarding disclosure, because that could have an adverse effect on their ability to claim in the future.
Robert, in your experience, would you say when you're taking out a policy, or when you're reviewing at the end of the transaction, explain to the client what the policy covers and also potentially what it doesn't cover, sort of setting realistic expectation with regard to that.
Well, I think that should be done before the policy is taken out, when you're explaining the options available to deal with a problem, or to help solve a problem, and certainly make it clear then. And as the test, which we always talk to clients about and stress when we're talking to lawyers, is we deal with financial value, with market value. We don't cover the emotional value that people put into particularly a purchase of their home. And clients really need to be aware of that. Yeah,
good. Thanks for that, Robert. Sue, hi Sue. Hey, look at that, Robert. A bit of a review for Stewart Title. Robert, I think next time when you talk to the Americans or Canadians about a pay rise, just look what Sue said there. Policy from Stewart Title, least covered 4 houses being lost, same day quote, policy on risk. What a service, and good, reasonable premium too. Hey, Robert, how about that? Any comment from Sue's statement there?
Well, I mean, that's a wonderful statement, and we'll have to look at those premiums. If people are thinking they're reasonable, we need to do something about that.
Absolutely. Good. Thank you. Ever the opportunist, Robert. I like it. Right. Robert McNally. Hi, Robert. Think also the broker lawyer should remind the client to monitor and keep the limit of indemnity under review. Property values increase. Absolutely. On that point, Robert, Stewart Title, I know your policies increase, don't they?
They do. I was just about to say, you have 10% increase for the first 10 years. So if you buy a policy for 500,000 today, after 10 years, it's worth $1 million. So that covers most inflation. But I know where Robert's thinking, if you've developed or changed the use of the property to keep it under, to check that at time, particularly if you're being offered the benefit of a policy in the future, make sure that level of cover is sufficient, and you can always look to top up. And you can also, in most cases, insurers will be willing to offer top-up cover, even if they didn't issue the initial policy. They may want to underwrite the risk again just to make sure, but you aren't necessarily tied to the original insurer.
Great, good. And Robert, the other point I've made in the past is your new underwriters, etc. I think conveyancers need to know that they could come up against something they think is unique, and they could be sitting at their desk thinking, what do I do with regard to this risk? Do I take out a policy? Do I investigate? Do I just forget about it, etc.? Your underwriters and you, Robert, are encountering issues on a daily basis. And my guess is there won't be much that you haven't seen before. And therefore, I think that conveyancers should, in addition to using your product, use you and your colleagues as a resource as in the sounding board. You know, I've got this issue, what do you think? And it may be that an underwriter or your good self can say, well, yeah, we've seen that and we've got a policy that covers it, or we've seen that and liaising with the lawyers involved, this was the strategy that they adopted, or this was the approach they adopted. So I think there's a benefit in your having expertise and you're encountering risks and issues on a sort of daily basis. What's your view on that, Robert?
Yeah, well, that's entirely right. I mean, hopefully most conveyancers only encounter title risks on an infrequent basis. But every piece of post that comes across our desk is about a title risk, about a title problem. So yes, we are dealing with them every day. In many cases, you know, we've dealt with a similar problem. In some cases, we've dealt with a similar problem in the same area and are aware of the chances of enforcement by certain landowners and neighbours and so on. So yeah, we're always happy to discuss the problem with you and to see solutions there. And obviously, part of your job when getting insurance or suggesting insurance to your client is a proper demands and needs statement, which will also talk about other remedies and other solutions that might be available.
Good point. Yeah, good point. Thanks for that, Robert. Good. The last thing I want to talk about, Dan, remember, it's your topic, so put in anything you want. Christopher, you raised a question there. Robert, can you deal with that in the chat while I talk about this case of Cowdery against Gibson? One of the most bizarre cases I've ever seen. I don't know if you've read about it, but I've done a long report on it in Property Law UK. And the reason is you had two landowners, properties in Kent, basically farmers and landowners. And you had one farm owner, the claimant, Mr. Cowdery, who wanted to sell his farm. And you had a neighbour, a Miss Gibson, who clearly, and I haven't got the bottom of it, had some form of private grief or grouse with Mr. Cowdery. So Mr. Cowdery's selling his property for quite a lot of money, I think £3.5 million, etc. He finds a buyer, and then Miss Gibson starts generating all manner of claims and complaints, and insists that the solicitors for the seller notify the prospective buyers of those complaints, and, to add insult to injury, communicates directly. Okay? So as far as that's concerned, you have allegations that the property being sold had water, rainwater, that flooded onto her property. You had allegations that there'd been breaches of restrictive covenant, covenants in her favour, covenants in favour of others. So property being used for trade or business activity, properties being used as dwellings when there was a covenant to say they couldn't be used, etc., etc. So talk about mischief, okay? Well, I'll come on to that, Robert. Okay, Mr. McNally. You had allegations that a boundary dispute was still live and active despite an agreement that had been reached. A construction of a swimming pool, which was a breach of covenant. Conversion of outbuildings, it was a breach of covenant. Lack of planning permission. Right, so in essence, the court had to consider the defendant's behaviour. Was it malicious? And I'll just have a look at what the judge was having to decide. It's really quite interesting. So you have all of this sort of venom being spouted. So, claim made, number one, malicious falsehood, the telling of lies, and slander of title. Was there a publication by the defendant about the claimant which was false? Was it published maliciously, and did it cause damage? Well, the court said yes. You know, there were some very limited argument to say there was a problem with flooding, for example, or you could argue, a layman could argue, that occupation of a dwelling was a breach of a restrictive covenant, but it was a long stretch. There were other allegations that were being made that the defendant had no possible grounds to make, and it was just, as I say, venom. The next claim was harassment. Conduct that occurred on at least 2 occasions targeted at the claimant, objectively calculated to cause such alarm or distress, and the perpetrator knew or ought to have known that conduct was likely to cause alarm and distress, in that it was objectively oppressive and acceptable. So you had a claim for harassment as well. And the court said these claims are substantiated. The judge, I think, was really kind to the defendant in saying, well, all right, she's a lay person. Even where she'd taken legal advice, she may still have a bee in her bonnet about a breach of covenant or about flooding issues. So there was a minuscule element of truth in her contentions. But the judge ordered that she pay damages to the claimant's seller for the fact that the claimant's sale fell through. And that was the difference in value between the price that was to be paid by the buyer that backed out and the value of the property, £150,000. But the judge also awarded £9,000 for the anxiety and stress that the seller incurred relating to the effect she had on him. So this was £9,000 in connection with the fact that there was harassment, and even though it didn't affect the claimant's ability to work or anything of that nature, it was still sufficient to enable the claim to be made. Okay, he's entitled to damages for the anxiety and distress caused to him by the conduct of the defendant. A really, really interesting case to look at. The judge also looked at whether or not, and this is again another reason why the case is interesting, looked at the enforceability of easements and covenants. So there's quite an interesting or series of interesting passages about how you ascertain if a covenant or an easement is in fact enforceable. So a great case that's well worth a look at, and as I say, is reported in Property Law UK. It is, ladies and gentlemen, 2 minutes past 1 o'clock. All that's left for me to do is to say, if there are any topics that you'd like to talk about next time, put them in the chat box or send me an email. A massive thank you to everyone that's participated, Mr. McNally, Mr. Wright, Ms. Brooks, etc. Thank you all for attending today and contributing. A massive thank you to Mr. Robert Kelly, Mr. Richard Pickles. And again, everyone that turns up for these things, I'm so grateful of your time. You know, you make these events. Do drop me a note if you have questions or queries for next time, or if there are any topics. Last point before we finish, anyone got any questions? Zoe, as ever, a pleasure. Sue, again, always a pleasure, of course. Anyone got anything else to comment on in the chat? Fantastic. Just before we finish, email contact details for me, details about Property Law UK, and remember, have a chat with Ian with Robert Kelly about the fact that Stewart Title have some free subscriptions that I'm sure they are willing to share. On that note, thank you very much, everyone. Stay safe. Speak soon. Thank you. Bye-bye.